Mini trial in alternative dispute resolution.
Mini trial is an ADR procedure, in which a neutral third party assists the parties in evaluating the relative strengths and weaknesses of their respective cases. Mini trials are usually conducted by agreement of the parties. Retired or former judges frequently serve as neutrals for mini trials. Mini trials are frequently used as a means for corporate executives to understand and evaluate the issues involved in a dispute and each party's respective position on those issues.
Once the parties have agreed to have a mini trial and a neutral has been selected, the neutral will schedule a meeting with the parties and their attorneys.
At the meeting, each party will present an abbreviated version of their respective evidence and legal arguments to the neutral and the opposing party. After hearing the evidence and arguments of the parties, the neutral may give an advisory opinion on the likely outcome of the dispute.
The neutral may also assist the parties in conducting settlement negotiations. Like mediation, many trials are confidential and non-binding upon the parties, unless a negotiated settlement is reached.
Distinct from any other ADR method, a mini trial involves the top decision-makers of the corporations having a dispute by engaging them in the presentation of their respective cases and the subsequent negotiating process. The top executives representing each of the businesses having a dispute hear their own attorneys argue their respective cases as if it were a conventional trial. These executives sit in a panel of 3, the third member being a neutral, independent counselor, previously chosen by the parties themselves from a panel who acts as moderator of the process, as a judge would. The neutral counselor may act as a mediator or conciliator after the case has been presented to help the executives reach a mutually satisfactory settlement. While mini trial rules and procedures are nowhere as strict as applicable rules of evidence or procedure in a regular court trial, a meaningful exchange of documentation between the parties will always contribute to strengthening confidence in the process, thereby encouraging a fruitful dialogue on settlement options between the executives involved in the process. However, protocols for the exchange of documentation are agreed to by the parties prior to the commencement of the mini trial.
Both parties must be represented by legal counsel. The independent counselor acting as president of the panel must be a licensed practicing attorney, and his functions are limited to managing the bureaucratic aspect of the process in accordance with the provider's mini trial procedures, issuing a report based on the argument of counsel for the parties, which details the likely outcome of the controversy in a court of law in his own professional opinion, engaging the acting executives in a settlement negotiation based on the offers for settlement previously advanced by each executive to the other, and assisting the executives in their negotiating process. The major difference between mediation and mini trial is that a mediator only facilitates negotiations between the parties. A mediator does not evaluate the case or provide an opinion on the likely outcome of the case. By contrast, the mini trial neutral hears evidence from the parties and generally gives an evaluation of the likely outcome of the case. Additionally, parties usually do not present evidence at mediation. Both mini trial and mediation are useful ADR techniques to help litigants reach a negotiated settlement to their dispute. A mini trial focuses more on the relative strengths and weaknesses of each party's case, while mediation allows the parties to search for common ground to negotiate a mutually beneficial agreement. Both parties present their respective arguments in writing at a time set by the neutral to do so. At a minimum, written arguments set forth both factual and legal arguments supported by whatever evidence they deem appropriate. The neutral sets a date for a hearing where the presence of counsel for the parties and the top decision-makers of each company will be required. The attorney for each party presents his client's case in an abbreviated manner previously arranged by the parties with the assistance of the neutral as set forth in the provider's procedures. After having heard counsel's arguments, the executives commence settlement negotiations with the aid of the neutral acting as a mediator.
If the executives are unable to reach an agreement, the neutral counselor writes an independent report describing the likely outcome of the matter, were it tried before a regular court of law. It contains his recommendations for a settlement of the issues. In accordance with most procedures, the executives meet a second time to continue assisted negotiations based on the neutral's report after having been afforded an opportunity to consult with their respective legal counsel. If this second stage fails to produce a settlement, then the parties may abandon the process, or they may present their respective final settlement offers to each other through the neutral. Should the parties opt to present final proposals, the neutral issues a second and final report containing his recommendations to each of the parties individually. If no agreement is reached at this stage, the mini trial may be deemed concluded, and the parties are free to explore additional ADR options.